Hi, welcome to all of our followers. My name is Stephanie Matza, Associate Attorney here at the Law Offices of Beltran Brito Casimir. By video, accompanying me is Gil Brito, the founding partner. Today, we're going to be doing a live Q&A in English. For those of you who are Spanish speakers, you may ask your question in Spanish. We'll go ahead and translate live, and we'll answer your questions. Some initial matters before we go into the news with Gil is please try and only ask your question once. That way, we can get through as many as possible. And again, we look forward to answering your questions. So Gil, how are you today? What's in the news?
I'm doing great, Stephanie. How are you? We have a little bit of immigration news. We're still waiting for the October visa bulletin to come out. The September visa bulletin, it's looking actually pretty good other than the EB3 category that has a little bit of retrogression. My expectation is October 1st, when the new visa numbers come out for that category, we're going to see some interesting movement in that category, hopefully giving a lot of relief to a lot of people that are waiting in that. If you have a labor certification pending, if you have an I-140 that's pending, you have an I-140 approved, you haven't been able to file your I-45 yet, they haven't gotten to their number, they're processing April 2019 cases, I believe. I think we're going to see a nice jump in that category. Family categories continue to be nice. Very stable still. Particularly of importance to our clients is the F2A category, which is going to be LPR spouses and children under the age of 21, Stephanie. The numbers are still current, which is fantastic. And I do continue to expect that to be current. Why is it current? It's current because there isn't that many applicants for that category, Stephanie, and that's the reality. Updates, we're seeing appointments, USCIS appointments coming in, flowing. I have marriage-based cases already being appointments. I have I-140 based petitions already setting for appointment for the month of September. And naturalization appointments continue, I think, to grow. That is going to crescendo, I believe, Stephanie, up until the election, probably a couple weeks up to the election. That does happen every 4 years. That's a normal thing that happens at U.S. immigration. You see a huge movement in the N400 category. And then lastly, we're seeing a piece of news come out from the Department of State indicating that to try to alleviate some of that backlog, Stephanie, that we're seeing at the U.S. consulates abroad because of COVID, they've been closed, okay? And trying to, all those people that are actually waiting for appointments, Department of State has said that they're going to start waiving appointments for visa renewals, okay? Meaning typically if you've had this visa category in the past, you're going to potentially be able to mail it in versus having to go to an actual in-person interview. They have yet to release any real information about that, what categories are covered, what visa categories are not covered with that. Also the actual process of doing it. I'm assuming it's going to be the normal thing, Stephanie. You set your appointment. Years ago, we would see this all the time in different consulates. This has kind of stopped in probably the last 4 years. But previously, if you've had that visa in the past, we were able to obtain renewals of the visa in the passport, and they would waive the interview. Okay, we would mail it in. It would be like a box that you would check saying that you're going to mail it in, the address, the courier information. You need to send it to the consulate. You would submit the MRV fee that you paid the fee, confirmation of your DS-160 form that it was filed online, and your passport and the approval notice or any supplementary information about the visa petition. That's how it used to be for work visas, for renewals of work visas. Initial visas, you're always going to have to go for an interview. They have not stated they are waiving that. Okay, so we'll have more information on that as we are actually going through it. We are seeing individuals that have visas that happen to be visiting the Shenzhen region, okay, they are unable to enter the United States again without requesting a travel ban waiver. Basically, every consulate has different requirements for it and what they want to see. For those individuals that are applying for it, where we have seen success is where you're able to demonstrate a financial need, an economic need, a work issue, a company in the U.S. that's going to be affected, financial, not necessarily your personal financial situation, but that of your U.S. employer. The fact that, if you don't come back to supervise a particular project that you're involved in or something, there may be financial loss. I think that would be a proper, and be able to document it, Stephanie, okay? That would be a proper way to try to get a travel ban waiver there. If not, I'm talking about you have a visa in your passport, you have a work visa already issued. You're going to have to go to a third country, be there a couple of weeks, and then be able to enter the United States. Keep that in mind. So a lot of clients are asking me this. They are here right now. Gil, I need to travel, and I'm going to go to Europe. I'm like, you got to be careful, because the reality is it's discretionary, the waiver. If not, you're going to have to, kind of assume all that cost of being in another country for a few weeks until coming back into the U.S. You might obviously have to do that for family reasons, medical reasons, whatever it might be. It's an emergency situation. Do it. Obviously, be aware that you might have issues coming back in. Okay.
Absolutely.
We're going to go through the questions. Stephanie, I'm going to let you tee them up for me. And let's call it Spanish to English. And I might respond in Spanglish if I have to. And we'll go that way. Okay. So let's go.
I'm going to go for the first question from Alan. He did his medical exam in September 2019. His interview was in March 2020. It was canceled due to COVID-19. When they reprogram his interview, is he going to have to take his medical exam again? Alan, the medical exam is good for 1 year. So you did it in September 2019. More than likely, you're going to have to retake that medical exam. What I recommend is the second you get the new interview notice, go to the same doctor and tell them, hey, listen, I need to update this medical exam because it's been over a year. It has to be within the year. We're already September 2020. So more than likely, yes, you will have to retake the medical exam. But I would just go to the same doctor. Hopefully they won't charge you too much. Okay, next question for you, Gil. Manuel asked us, his appointment was, salió al año, 7 meses me pusieron en un proceso administrativo. Okay, he had an appointment 1 year, 7 months ago. They put him in administrative processing for 1 year and 6 months. When they approve his case, he's going to be 3 years. He's going to have been married already for 3 years. Is he going to get conditional or permanent residency?
I mean, for me, it's that the day that it's issued, it's what matters, so it's like that administrative process might have been kind of a blessing in disguise, and you might get the actual 10-year at that point. Manuel, unfortunately, you're going to have to wait and see what happens, because depending on the situation that it was an administrative processing, they might take it from the day of the interview, meaning you will only get it for 2 years. I think you have to wait and see. I mean, I would assume it's going to be the 10-year. Okay, but it's possible that they say, Stephanie, it's going to be from the date of the interview, because that's it. That's when we would have but for the fact that it's an administrative processing. I'm interested to know, Manuel, if you can, just shoot me a little message on the bottom. What was the reason you were put in administrative processing?
Okay, next question from Aldine. He is in Mexico. He currently has an I-130 pending residency based on marriage. His question is, can his mother apply for a tourist visa? Will she be affected by the fact that son, is in an I-130 process? Aldine, I would say no, because essentially it's two different processes. What your mother is going to want to take to the appointment is proof of her ties to Mexico, that she owns property, that she has a car, that she has some sort of any property, that she has bank accounts, that she has a reason to return. The fact that you're doing your marriage-based process, I don't think is going to affect her tourist visa. She just makes sure she takes proof of ties to her home country. All right. Beatrice asks us, give me 1 second. Si solicito ciudadanía estando en proceso de remoción. Okay. If I request citizenship while I am in the process of removing the conditions on my green card, it will cancel the I-751. And so she doesn't recommend doing an N-400 until she does her I-751. Can you explain that process?
Yes, okay. So Beatrice, you filed the I-751 to remove the conditions of your green card. That means you had a green card that was for 2 years. You have a requirement, obviously, based on marriage. So you file an I-751 to go ahead and remove the conditions. The issue is, after you've been a green card holder for 3 years and you're married to a United States citizen, you are eligible to apply for naturalization. Here lies the kind of the question, and what should you do from a strategic standpoint? Can I file an N-400 while my I-751 is pending if I fulfill the N-400 requirements? My response is yes, you can, but they will not issue or render a decision on the N400 until the conditions are removed on the I-751. What I've seen in the past is it's placed on abeyance. The reason your attorney is telling you that is because she feels that it's just going to be a waste of time. I am kind of in agreement with that. I prefer just to let the I-751, Stephanie, play out, and then we go ahead. But that it cancels the I-751, that is not true. It does not cancel the I-751. The I-751 must be adjudicated first.
Humberto has a question regarding timeline. Biometrics were taken last month. When should he expect his EAD and travel and work authorization? Humberto, usually is going to take about 3 to 4 months after the biometrics, after the fingerprints are taken. But we have had situations where it takes only 1 month. So let's see, luck of the draw. On average, you're going to see 3 to 4 months. Okay. Alonso, Gil, for you, a question. His U.S. citizen wife requested estampillas. Requested food stamps 5 years ago. We got married in January, and we started putting together the case. The fact that the U.S. citizen wife got food stamps, is it going to affect his case negatively?
I mean, no, she was eligible for it at that time. I mean, it has nothing to do with his case. Now, if they ask, she might have an affidavit of support issue, Humberto. If you're not able to have the affidavit of support, if she doesn't comply with that, you might have to get a joint sponsor. That's not going to be, look, there's a mix there of public charge issue, Stephanie, as well. I mean, if I'm a United States citizen, I'm able to apply for all these public benefits. Okay, so it's like, does that affect his case? No, the only thing it would affect, if she cannot financially support him, he will need to have a joint sponsor.
Okay, next question from Daniela. First of all, she thanks us, so thank you. She is a permanent resident in February 2020. She married her spouse. On the USCIS website, it says that after July 22nd, they should be expecting their interview. For I-130 for LPR spouses, right now, we're not seeing too many interviews. I haven't seen a single interview for I-130 petitions, Daniela. We have started seeing employment-based interviews, so they should be coming.
I did, Steph. Yeah, we have a couple. We have a couple that I saw come in. These are people that already had it scheduled previous to the pandemic. It was canceled because of the pandemic, and now they've given them the interview again. That's what I'm seeing right now. So just think, Daniela, that you have approximately 6 to 7 months, okay, waiting because backlog of interviews, okay, Steph. So the reality is that people need to take that time into consideration. Typically for that case to have an interview, it might be a year. Now we have to add another 6 or 7 months onto it. So the reality is it will take a while. Okay?
And something important for Daniela is her original interview was July 22nd. Right now what they're rescheduling is from March. So wait, it's going to be a couple months. Her secondary question, Gil, is what kind of evidences should she bring? I'll let you touch upon this, but Daniela as well, we also have a video on YouTube that really delves into very, very detail about what evidence you should take to your interview. But Gil, maybe you could touch on it now.
I mean, everything that evidences you have a real relationship together. Bank, insurance, photos, lease agreement, property together, debt together, credit cards. Obviously it's going to be your civil documents. Obviously you have to take all that stuff, which is going to be your marriage certificate, birth certificates, things, your passports. If you've been married previously, certified copies of those divorce decrees, you need to take that with you. Final judgments of divorce, you need to take that with you. But the basic evidence is going to be demonstrating you have a real relationship. You cohabit the same dwelling, you live together, and you're actually married. And just think of your day-to-day life and the types of ways that you could document that. And that gives you a general good idea. But I do recommend, Daniela, we do have, I think, a couple really good videos on it. And I kind of break down, it's either me or you, Steph, or me and Alexis.
It's 3 of us. I think it's
with Alexis. That was pretty good. If you want, our team will link it for you. And they'll send that to you so you could go ahead and have that and just take a good look at that at the preparation.
I have a question from Jairo. Hi, Jairo. He's asking if we have any news from the U.S. Embassy in Bogota. Currently, we're being told that it's open, but we haven't begun to see really interviews with Bogota. In the case specifically of EB1s, just remember that EB1s will only be adjudicated starting in January 2021 based on the current presidential proclamation. For other types of appointments such as J's, H's, O's, we haven't begun to see it in Bogota. We are being told they're open, but we haven't seen them yet.
I think they said F's what they're going to be doing now. It's going to be student visas initially. It's going to be Fs and Ms. I did have an interesting experience with a green card client this week that the doctor reached out to them because they had a pending medical. So the doctor that does medical exams for the consulate is reactivating cases again. So that's actually very encouraging and quite nice. Okay. So Jairo, hopefully that starts to pick up soon. I am predicting October that we're going to see a lot more movement in Bogota.
Gil, you're going to love this question from Adriana. I received the pink I-693 deficiency notice on August 11th. Any idea what this means? And does this mean that they have approved everything on the I-45 but that?
No. Adriana, when you receive that notice, that used to be called a courtesy letter. Now it's a deficiency notice. Words matter, I guess. Listen, it's going to say something to the effect, Adriana, that you filed it without the medical exam. Take the medical exam the day of the interview, whenever the interview is scheduled, unless that document says send it in. So unless that document that you have says, and it's a request for evidence, not just a deficiency notice, but my experience, the deficiency notice, they say the day of the interview, take the medical exam.
Gil, we have a question from Victoria. In 2018, she was before a judge for cancellation of removal. Prior to that, we submitted a motion to reopen for new evidences. The motion was approved. Is she still going to have to go to court?
Yes, I'm pretty sure, Victoria, you're still going to have to go to court. I'm hoping you have court counsel, immigration counsel for court. If you do not, I highly recommend finding a immigration attorney that handles court and has experience with cancellation and removal and has great experience with motions. And I would have that consultation very soon.
Maria Violeta asks, my boyfriend and I have plans to get married. He's in Puerto Rico. Does it affect that he's receiving food stamps? Gil touched upon this before. Essentially, he as a U.S. citizen can receive food stamps. It's not going to be an issue as far as, whether or not he can do it, it's fine. Will it possibly raise some sort of flags for public charge? Yes. And will it possibly raise a flag for affidavit of support? If he's on food stamps, then more than likely you're going to have to get a co-sponsor for your affidavit of support to show that a secondary person other than your spouse will be able to support you financially. Gil, next question from Elizabeth. She entered with a tourist visa with her daughter. They have a petition, an I-130 petition by her mother. The mother is requesting the
mom and the grandmother is petitioning obviously the niece and the mom.
Should I request, she overstayed her visa, should she request a pardon, I-601 waiver and leave? How should she handle it?
It's complicated. I've been there. As long as you depart the United States under the age of 18, and as long as you enter legally into the United States, and the U.S. government does not pay for your departure from the United States, that is not going to be a bar to obtain a green card in the future traditionally, and they typically would not. But the issue is Elizabeth herself, right? And the actual main beneficiary, Stephanie, is going to be. That's the issue. Is she going to be able to go ahead? Because as I understand, Elizabeth needs a perdón too, which is going to be a waiver. And the reality is, Elizabeth, you're going to have the issue with the waiver, not your daughter. Okay, so much. So yes, you're probably going to have to request a waiver. It depends how long you've been in the United States without status. Really quick, just to pause, be advised. If you are outside of status in the United States after the end of your non-immigrant visa status expired, non-immigrant visa, let's just talk for the instance of this example, tourist, and you've been in the U.S. out of status for more than 180 days and you depart, you're basically banned for 3 years unless there's a waiver opportunity. If you stay in the United States longer than 1 year without legal status and you depart the U.S., and do you see that I'm emphasizing the departure? Because that's the issue, okay? You are triggering this bar upon departure from the United States. Depart the United States after that 1 year of being out of status, Stephanie, you are not eligible to enter the United States without a waiver for 10 years. It's called the 3-10-year bar, okay? So people need to realize that, yes, when you say perdón and stuff, it has to do with that I overstayed, okay? So we need to be very careful. Sometimes it's not evil, it's not very, maybe it's not the best idea to depart. Every case is different. and I suggest discussing it with immigration counsel prior to leaving the United States. It's advisable to make sure you're doing everything correctly. Sorry, Elizabeth.
Belinda asks, in October 2019, she took fingerprints. She had filed an adjustment of status. When she filed her I-45, she never asked for a travel or work authorization with I-765, I-131. She hasn't gotten her appointment yet, should she request it now. Belinda, you certainly can. You can now file the I-765 and the I-131. A word of caution. If you filed, let's say you filed your adjustment of status and you were out of status at the time that you filed because you're married to your U.S. citizen spouse, then when you apply for a travel authorization, I-131, they will give it to you, but you should not travel. The word is do not travel if you were out of status at the time you applied for adjustment of status. You can certainly apply for your work authorization, your I-765 right now. And good to know is because you paid the fees for the I-45, the I-765 work and the I-131 travel are included. There's no additional fee. You can certainly file it now. Gil, next question. Horju asks, I'm from Nigeria. I want to come to the United States to visit. What are the documents that are needed?
As far as I understand, I'm not sure if they're issuing in Nigeria. I'm almost 100% Nigeria subject to the ban, Stephanie. And that's the actual, we will not issue you a visa ban. Okay, so that's the initial list of banned countries for visa issuance. Now, I'm pretty sure that there's exceptions to that as well, Horju, so you might want to take a look at it. But if you go to the U.S. consulate website for Nigeria, it's going to tell you that all visa processing has been suspended. That's going to be due to COVID, obviously, and the worldwide pandemic. But on top of that, I believe that they're just suspended. I don't think that you're going to be able to apply for a tourist visa right now with Nigeria. Check out the website to make sure you could attempt to make an appointment and go about it. If you do decide to do it, you need to show strong ties to your home country. That's going to be job, bank account, house, car, family ties. If you have a whole bunch of family members, Stephanie, that are here in the United States, and that have maybe overstayed a visa, applied for asylum, done, our green card holders, U.S. citizens, all this stuff, that potentially creates a little bit of a problem. I'm talking close family, obviously, not like cousins and stuff like that. But I mean like mom, dad, son, a sister that have done all this and maybe overstayed visas in the U.S., that there's going to be a higher propensity of having a visa application denied. Try to make the appointment. And if you're able to make the appointment, just take as much as you can demonstrating those strong ties to your country. Okay.
Perfect. Okay, next question. Maddie, can a person get out of the public charge in immigration if they no longer receive assistance? So Maddie, what you're going to want to do, the public charge form has a lot of questions, okay? If you no longer receive assistance, it's going to be important to basically notify that you no longer receive assistance. That being said, you're still going to, if you're filed your I-944 already, and you already indicated that you have receiving assistance, if it's not going to be affected at this point, you've already submitted the form. One important thing, if you're submitting the form now, if you haven't submitted the I-944 yet, there's no need to submit it. Right now, there's currently a pause on the I-944 and there's no need to submit. So yes, there might be a question, if I remember correctly, have you ever received benefits? You would need to disclose that, but you would have the opportunity to say, I no longer receive the benefits. Gil, a question from Anna. For the I-131, she's a conditional resident for her conditional resident, her and her son. They both have B1, B2 visas.
Yeah, it's not approved yet. So their green cards are not approved yet.
Correct. The I-130 was filed, but they have tourist visas. Can they enter the U.S. in order to do an adjustment of status?
I wouldn't do it, Anna. She's saying there, can I stay processing outside and my son entered to go to high school here in the United States and process an adjustment of status over here? I find that to be really problematic, Anna. So even though you might, maybe if both of you are going to do it and go about it, I still don't like it once that consular process, Stephanie, has already started, to go ahead and enter the U.S. as a tourist and to go ahead and do everything and cancel that and go the adjustment of status route. I don't advise it, and I don't like it, and it's not recommended. I think it's very problematic.
Good. I just want to jump back really quick to Horju from Nigeria. We've just taken a look, and non-immigrant visas are not affected, only immigrant visas.
Oh, great. So you can apply. Fantastic.
Mm-hmm.
Fantastic.
Perfect. The next question from Tantorin. We uploaded the DS-260 to the NVC. He says that the civil documents will be sent physically because SEAC doesn't give the option to upload them. Is that correct?
Sure. We have to send all the time to the MVC physical documents. I mean, I do it every 2 days out of my office. We're sending NVC packages just because we were not able to upload the documents. The actual MVC platform itself, Stephanie, not only is it a little convoluted, it's not the best. It's not the best for uploading documents and updating it. You have to have a particular browser, and it could be that day. You know how many times we're stuck trying to pay the fees and we're not able to pay, like it's like a whole thing. So yeah, that is true, by the way. And it's not the best. And by the way, everybody thinks that, we're just not doing it. But it's not that I'm not doing it. We're trying, and we're really trying to upload it, and it's just not working. So that's why many times you have to go ahead and mail it out.
Marco has an excellent question that we were actually discussing today. My partner derived his citizenship through his parents, but they only got him a U.S. passport. Can we file my I-130 with just his U.S. passport? Marco, yes. So basically, the U.S. passport is excellent evidence that this person is in fact a U.S. citizen. Okay. If they happen to RFU you and request additional evidence, then you could do something like showing that the parent got the birth, the parent got the U.S. citizenship, and then show that he was under 18 at the time. There's a lot of things you can show at that time. But yes, the U.S. passport is absolutely fantastic evidence that you are in fact a U.S. citizen.
I would go ahead and say to Marco also that make sure that derived citizenship was derived properly, okay? Because I've seen recently that they will send the passport to somebody that is not eligible for it. So you're now going to open up potentially a Pandora's box there for your partner. So it's just, like make sure, like what Stephanie just said, make sure that everything's in order and obtaining that was done properly. And if it is, that's great. You don't need a naturalization certificate. If you actually look at the law, there's 3 items. It's going to be a U.S. passport, a naturalization certificate, or a U.S. birth certificate. Is sufficient evidence to prove U.S. citizenship for the purposes of filing an I-130 petition.
But yeah, your point, Gil, is excellent. They could, in fact, reopen the U.S. citizenship.
We just saw it in the last 2 weeks. I've already seen that. So that's why I'm telling you.
So Patty has a question for you, Gil. I'm a U.S. citizen and petitioned my husband, who overstayed for 16 years, with his tourist visa he entered. USCIS received our paperwork December 2018. How long does it take for our interview? We live in Seattle.
I mean, it's, traditionally, like what I'm going to say, West Coast traditionally is hovering around a year to 13 months, probably, to have an interview. Now you get COVID in the mix and you got an extra 8 months to that. So go 18 months. Okay. So technically that should get you more or less to now. Okay. Roughly. I would not be surprised, and you can start getting ready for the interview, Stephanie. Now start getting ready for all that. Get your documents in order. Get everything ready for it. Like everybody waits until the interview notice. Then the interview notice comes, and they're like, "Oh, I don't have a copy of the birth certificate. I don't have the proper, or I don't have the original of this document, or whatever." Get all the documentation together already, and I think it's very likely you might have an interview this year. Do not be surprised early next year.
So, Gil, I'm going to give you this question. Nirvalma has 2 questions. Okay, so I'm going to jump around.
Sure.
Nirvalma's first question is, how can I show that my husband comes back and forth from Tijuana in order to visit her? I think she's good evidence to show that they are in fact married. Her second question, Gil, after you answered that one, is just a legal advice. Her immigration lawyer is not answering her calls or emails. They've already paid for the full process. What should we do? Okay.
So let me go to the first thing. Number one, I used to do this a lot with Canada in particular, more even than Mexico, but it's a pretty good strategy, I think. So what we would do is the day that he's going to cross Nirvana, he should go and make ATM transactions. He should use his debit card to purchase gasoline. He should go and buy something at McDonald's and have evidence that there's some food. Then the same day, I want to see transactions on the other side. Okay, I want to see transactions on the other side. Obviously, you guys are going to take photos together. You're going to be able to document your case other ways that you got, on vacation, this, that. I'm assuming. If not, that is, you need to definitely have good communication with one another. I think things like WhatsApp, text messages, things of this nature. So that's how I would probably approach showing that he actually goes to see you. It's ridiculous, but you know what else I would do there? And I haven't used this as evidence, but it just, I don't know. Things just come to me, Stephanie. So how about Google Maps, man? How about throwing, you have your own Google account. It's on your phone. I get an email from Google every month telling me everywhere I've been, nowhere because of COVID. And it's like, and it tells you all this stuff everywhere we are. I'm like, that's pretty interesting evidence that, I guess people could fake that by being somebody else's or something like that. But it's like, no, why? You know what I'm saying? It has an IP address. It's linked to your cell phone. It's your phone. It's like, I think that's good. That's also good evidence. I mean, I guess you could fake the transactions and stuff like that. Going back to the transactions, hopefully it's things where you're signing a receipt. You can keep the receipt. It has your actual signature on it. That's, that's just, I think, thinking outside the box a little bit on how we could document that. And if you want there, and if you can, and I know it costs a lot of money to do this on Nirvalma, but I would say maybe do at least 1 or 2 trips on an airplane. And right now it's not too bad, particularly to Mexico. The flights are really inexpensive, and just do like a budget airline or something like that, and just take a trip over there, come back in a couple times. That that's just going to help supplement the case. Going back to your attorney not responding to you, man, we don't have these clients. Listen, we respond to people. It's not always what they want to hear, but the response is important. Attorneys have an obligation to go ahead and make sure it's an actual attorney, not a notario. Because when you go to notarios, that is not an attorney. If you're not going to an attorney, there is no ethical obligation. There is no legal obligation for those people to that's a business transaction you did with that individual. I have an obligation as an attorney to go an ethical obligation, and let's just even call it a moral obligation to respond to people and to take this stuff very, very seriously. So I would tell you that I would contact him 1, 2 more times via email, and I would make sure that they understand that you're going to be contacting the bar of whatever state that is, which is the professional association, if they do not hear from you very, very soon, and understand what's happening with your case. Okay, that you have a right to that, especially if you paid for a service and you have a representation agreement with that attorney. You have a right to that counsel.
I'm going to jump back to a question from Adriana. She followed up. This person she received the deficiency notice. Adriana had been living with her USC husband for over 6 years. They got married in November 2019, filed January 2020. She's concerned that she filed too soon, and she thinks that's the reason for the deficiency notice. Adriana, that is not the reason for the deficiency notice. You did not file too soon. You could have filed on November 20th. That's as simple as it is. As long as you can show that the relationship is real, you guys have lived together for over 6 years. What better evidence than that? You're perfectly fine and you did not file too soon. The I-693 deficiency notice is only to tell you that they're missing some sort of document and that they're going to require that you bring the document to the appointment. More than likely, usually it's going to be the medical exam. So they're going to send you this notice that says, hey, you don't have this. Make sure to bring it to the your appointment. It is not because you filed too soon. You guys have evidence of 6 years. There's no maximum or minimum in order to file.
Definitely, okay? To follow that up, that comes from somewhere. There's a lot of talk and a lot of information that says there's this idea, and a lot of attorneys talk about this. They're like, oh, after you get married, you should not file right away because then they think you're committing immigration fraud. Listen, they're going to investigate you no matter what. Okay. So I'm not with that. Okay. I like 3 days later, like I've done this. Divorce on Monday, marriage, license next day, 3 days later, ceremony. Following Monday, cases at USCIS. Okay. That's all been approved. Okay, because it goes to the validity of the marriage. And if it's actually a real marriage, it concerns me zero. Okay, and that time is fine. There's no issue with that.
Absolutely no fine. Okay, Jessica asks a question, Gil, for you. How long does an adjustment of status take? What are the sort of timelines right now?
Depends on what category particularly. Is it a concurrent filing, Jessica? I'm assuming that we're probably going marriage route here. Get ready for 18 to 24 months for green card in hand. And that's what I think.
Sorry, so, her follow-up is, what if it says that it's ready for an interview?
Oh, okay. If it says it's ready for an interview, I'm thinking about 6 to 7 months, because I've been seeing a lot of those ready for interview on the online platform of USCIS, Stephanie. A lot of our clients follow the track of everything that's happening. And it's not just the when you put in the receipt and you see the case number, they're doing the track. I highly recommend for people to go ahead and register themselves, have that track, so you know everything that's happening. They'll even text you when there's any movement on the case. After that notice, I'm typically seeing 6 to 7 months for the interview.
Gil, I went ahead and I was checking up on this just to confirm my instinct. We had a question regarding how long does the I-526 take to be approved. From our last one that we saw approved, I believe it's something in the neighborhood of 18 to 20 months.
22 months, I think, is typically what you're seeing.
2 years.
If you're going off what is on the USCIS website, that processing time, it's kind of ridiculous. It may be up to 48 months is what it says online. That is, I haven't seen a 48-monther. I can't tell you that I've seen that in our office, but the USCIS website does say that. I would say I'm generally hovering around 22 months as normal. Okay.
Perfect. Next question, Gloria. She married a U.S. citizen. She's currently in a process of asylum. Can she apply for adjustment of status and travel without an issue?
Gloria, no travel. Number one. Number two, a lot of factors there. Are you already in proceedings? Was your asylum denied? If your asylum's denied, you could do the whole application, but you must do it in front of the immigration judge. If this is pre-asylum interview, you get married to a United States citizen, you've already filed you could file the I-130 and I-45 and employment authorization. You could apply for an I-131, the travel document, Stephanie. They will give it to you. I'm telling you, Gloria, do not travel, because if you travel, I am of the belief they might not let you enter again, and they require you to process everything outside of the U.S., and you will likely require a waiver at the consulate, which may not be approved. Okay. So talk to your asylum counsel and the best time to withdraw that asylum application. I have different opinions on when to withdraw that asylum application. Every case is different. So depending on the necessity of your case, depending if you were in legal status, if you were not in legal status, a couple of other factors I look at, I'll either withdraw that after the I-130 and the adjustment of status have been filed, or I wait until I have a green card to withdraw that process. I mean, so the idea though is to be able to do that prior to having the asylum interview. If you're post-asylum interview, it's a different ballgame.
Gloria has a follow-up question. Her son is in Venezuela. Can he begin his process, or is it better that he enters with a visa? Gloria, certainly. So your husband can file an I-130 for his stepson, and then what they could do is they'll do the I-130 consular processing. They can absolutely file right now. They could begin right now, have him file the I-130 right away, I would say.
Stephanie, how about the age of the son?
That is an excellent question that we don't have. So The important thing is you have to be married before your son turns 18. So before your son turns 18, the step-parent relationship has to be established. That's an excellent point, Gloria. We have to make sure your child is under 18 at the time of the marriage. Nika Flores, how can I go ahead and do a formal consultation? Nika, you go ahead and on the bottom of the screen, you see info@beltranbrito.com. We check that email regularly. So go ahead and send us an email. Give us a quick description of what you have a question on, and we'll go ahead and set an appointment with you. Rosalinda. ¿Cómo pasarle I think that's the same exact question. We had the two same questions back to back. Okay, let's see. Let's see. Dan, thank you so much for your questions. Carolina Rivera. I filed the I-130 online, petitioning my mom as a U.S. resident. I'm a citizen. Then I received the I-797. I sent the I-797 and the I-45 by mail to the Chicago P.O. box. Did I do it right? I
think every I-130, I-45 is Chicago lockbox. I think that has not changed. It was either Arizona, Chicago. I never love the hybrid, Carolina. I don't like the file one thing online and then file the paper copy later on. It's fine as long as you have the receipt. But, it's like I just always think that confuses things a little bit. What does it look like, Stephanie, for her? Keep looking.
I'm checking it out now. Exactly.
It's always been Chicago lockbox for like the last decade. It's been
for a very long time.
Yeah. I'm almost sure that's right. The most important thing is, thank you, Dan. The most important thing, as always, Carolina, is, okay, when did you do this? Have you gotten the I-45 receipts? I-45 receipts take about 5 weeks generally to be issued for some reason, particularly based on I-130. Now, number one, it is. Okay, you're good on Chicago. You're good on Chicago. Check out, Carolina, the cancel check. Okay. I love looking at the canceled check because when I'm getting kind of nervous, I haven't gotten a receipt on a case. I look, Stephanie, yeah, because sometimes it's a legal status issue. And it's like, why don't we have a receipt on this case? Okay. And that's kind of what's happening, Carolina. So go ahead and look at the canceled check. If it's a money order, you could request a copy of that money order, cashier's check from the bank. You could request it, your own personal check, go online, look at your bank account, look at the back of the check, the case number's there. Okay. And that's going to give you a little peace of mind just in case you don't get the receipt. And if you don't get the receipt after 45 days, guess what? You have the case number, call immigration, tell them you didn't get the receipt. I need to get the receipt. Okay. And they'll resend it to you.
Sonia has a question. So what's going to happen with individuals who are here due to the pandemic? Sonia, the important thing is, let's assume that you're here as a tourist. Before your I-94 expires, before your status expires, you have to apply for a B2 extension. You have to apply for an extension in your status. Just because of the pandemic doesn't mean that you should not maintain your lawful status. You must maintain your lawful status. Even despite the pandemic, if you begin to acquire unlawful status, you could eventually fall into what's known as the 3 and 10 year bars. So you must maintain your status even though there's a pandemic. Tanya Manuel Gill, her spouse is a green card holder. She is in the military. Do these immigration bans affect us?
You know what? I think for military, particularly and servicemen spouses, it does not, Tanya. Really cool. I just Google this USCIS phone number military. Okay. And that's going to be the phone number. It's like 1-800-246, something like that. And you could call that number to see what's going on with your case. It does not affect it. But in case, that's a special line for military families. So that's nice that you could bypass all this other thing where everybody's, calling and getting information. You're going to talk to an officer and they're going to tell you what's going on with your case. You know what? Do that every once in a while. Why not? Okay.
Absolutely. Okay. Delphus asks, I got an I-129 approval for an H-1B on 7/6/20. My family's I-539 applications, H-4, were received on June 20 and June. Fingerprints were taken in July. No response so far. CAPGAT ends in September 2020. Any issues? Delphus, no, essentially because these petitions were filed prior to the CAPGAT expiration. You're perfectly fine. It is normal that the H-4 will take slightly longer than the H-1B. You're fine there. And as long as you should keep waiting, once you get to, I would say you filed in June. Once you get to December, I would maybe do a service request on the H-4 petitions online. Okay, let's see. Next one, Gil. How long is the average to receive the first round of confirmation notices after filing I-485, I-131, I-765?
About 5 weeks. 5 weeks.
How long to receive an EAD from a marriage-based petition?
6 to 7 months.
Yeah. Okay. Nirvalma has a follow-up question regarding the travel, Mexico.
Yep.
Should she print screenshots of the WhatsApp calls in his Google history, or can I bring myself into the consulate?
Print everything out on paper if you can. Yeah, print it out on paper always. I'm hesitant on taking the phone to the consulate. That's always been kind of my thing. Like, I don't know. Like, do I want to give people my phone? There's a ton of info on that. So I'm generally not a big fan of that. So no, I don't love that. You can if you want to. And if everything else is clean on there and there's no issues regarding anything, then that's fine. You can, but always print out everything just so they can put it in the file.
Danny, this is a sticky question. Does someone with an O1 visa, can they work for another job, for example, Uber Eats, to pay the bills? Danny, when you have an O1 visa, you can only work under the title and under the conditions that you requested. Let's say you petition for an O1 as a musician, you have a representative, you can only work in that capacity as a musician. Now, your other question is, can someone with an EB1 do supplement with Uber Eats? EB1 is an immigrant visa petition. So you have, if it's approved, you have permanent residency in the US. You're not limited only to your field as a musician, even though you petition as a musician. At this point, you are a permanent resident of the US. You can work in any field you wish. If you have an I-140 pending and you have a work authorization, I would be very delicate because you're petitioning as a musician and you want to say that you want to come to here as a musician. I would be very delicate with Uber Eats. Technically, with an EAD, you can, but I would not.
But that's different, right? So I have an EAD. Can I do this? The issue is this my primary income? Is this my primary job? And if it becomes your primary income stream, Stephanie, I think that that's a problem. If it's supplemental, is there a requirement? No, you need to. Your main profession is going to be, in his case, for example, let's just say, acting or performing. Okay, it's going to be. So that's the main focus of my EB1. That means that I could only do that for the rest of my EAD when I have a green card, when I'm a U.S. citizen. No, it doesn't. But it should be your intention to continue working in the field always. Okay.
Alexander, I am married to a U.S. citizen. I did my petition on August 27th. I entered with a tourist visa, and that expired in January 3rd. So he filed after the fact. His sister said he needs to file with a 601 waiver. Is this necessary? Alexander, no. Your sister's wrong. Basically, if you are married to a U.S. citizen and you enter as tourist visa, it doesn't matter that you overstayed because you're married to a U.S. citizen. There's a specific permission, or it's allowed that you're out of status as long as you entered legally. Now, could you require a 601 waiver for something else? That is a different story. Maybe she's implying that you need a 601 waiver because you have some sort of other issue in your petition. If it's only because you filed late, no, you do not need a 601 waiver.
Alexander, you could be out of status 20 years in the United States and still be eligible to a green card based on marriage to a United States citizen. Huge difference, Stephanie. United States citizen marriage versus LPR marriage. So if your spouse is a green card holder, you can't do that.
Right.
Okay? Just keep that in mind. Next.
Jose Miguel. I have an I-600A pending approval. I am married with a U.S. citizen. I submitted the application on May 7, 2019. In which moment can I receive a work permit?
Is he saying? I think he means an I-601A.
I've got to assume.
Yeah, I'm assuming that you guys filed the I-130. They have not filed the adjustment of status application. Jose, go ahead and contact us separately for an appointment. And if I see some of the documents, I could go ahead and tell you what's the best route to take there.
Karina, in your experience, what may be the reasons for my spouse to receive his I-485 approval first and receive his green card if I'm the main one in the labor certification petition? Karina,
there's no reason, Karina. Karina, there's no reason.
Yeah.
That's probably USCIS not realizing it, and that's something that hopefully could easily be fixed just by calling and us being on top of the situation. So I'm not personally concerned about it. The green card will happen soon.
And check the online, because one important thing is maybe they approved it and then the green card just didn't get to you. Maybe the green card came in the mail to your husband, but not to you. So check online, make sure that it was sent and that it's good to go. Yeah,
Stephanie, no. Yeah, me and Karina we're tight. I know the whole story. Don't worry.
Got it. Okay. Next question. Let's see. We have a lot of thank you everyone for listening. Delphus. Hi, Gil and Stephanie. Thank you in advance for your response. I got my, we already responded.
Yeah, we got Delphus already.
Yep, my apologies.
Let's go to Yvetzi.
Yeah, that looks like the next one.
Yep.
Okay. My question is, can we go to the interview with my child, or is there a possibility that they include her in the petition because she's 7 years old?
No, she has to go. Everybody goes to the interview. Yeah.
Yeah, include her in the interview.
Yeah, everybody.
Take everyone to the interview. They'll let her in.
Carla,
I'm a DACA recipient. I entered illegally. Gil, the question left. I entered illegally. I married a USC Navy vet. How does changing my name to his affect me?
Nothing. I mean, if you're married, you can change your name. The thing is, are you going to be able to get a green card based on this marriage? And the reality is, if you enter illegal into the United States, even if you're, I believe, Stephanie, even if it's military, it does not affect it. Okay. I mean, it does not help it. You will require a waiver at some point and process everything outside of the United States. Changing the name. No, you can change your name. I mean, that's fine. If you're married to somebody, and the state allows it, and that's not an issue, you could just go ahead, based on being married, you could go ahead and start utilizing that person's name.
Yvetzi has a follow-up. So so she has her interview abroad, but the I-130 petition for the daughter is with USCIS still. Yeah, there's still no issue that she attends to the interview with you. That just means her I-130.
Oh, I understand. But who's the petitioner? The father, I'm assuming?
Probably the stepfather.
Okay, so the stepfather. I mean, the stepfather's going to go to the interview with her.
Yeah.
Yeah. Anything else?
I believe that is it. Let's see.
Gloria. Gloria, work authorizations are not extended automatically. You must apply to renew that work authorization.
Alexander was the one, whether or not we need an I-601. He already sent it.
Okay.
You already sent it at this point. Whether or not they're even going to adjudicate it is a different story. They may just choose to ignore it. So don't be concerned that you already sent it. Marcy, we are live.
I'm sorry. Alexander, he needs to withdraw that 601.
Okay. Withdraw the 601.
Yeah, withdraw the 601. You don't need one. It's unnecessary.
If the reason, again, is because you applied late, because that's not reason.
I just don't understand why. Right. So it's like if you entered, if you actually entered legally, okay, and you're married to a United States citizen, there's no need for a 601 waiver unless there's something else, Stephanie,
that we don't know.
That we don't know about. Okay. Other than that, I mean, if there's no criminal issue, if there's nothing like that makes you inadmissible to the United States and ineligible to apply for a green card, then go ahead and withdraw that 601. It's unnecessary.
Tiger, excellent question. How long is the F2A category in 2020? So F2A, something that didn't happen, 2 years ago, is currently current. So those who are spouses of LPRs, of green card holders, they are current in the visa bulletin, meaning that the wait time is pretty much the same as a U.S. citizen. I'm talking maybe a year for your I-130 usually to get approved. And depending if you do adjustment of status or abroad, it may be a little more than that, but it's going very quickly.
Well, thank you to everybody. Very much. You're welcome, Gloria. I think we are wrapping up. And as always, feel free to contact us, info@beltranbrito.com. You could go ahead and call us. The phone number's there on the bottom. Emailing us generally is maybe a little bit quicker. We review the question. If I can, Stephanie, I always try to respond right away to give a response, or we tell you, listen, we need more information, or we suggest to have a formal consultation. Go ahead, Marcy, give it to me. Marcy, wait. Go ahead, Marcy, give it to me. I've been waiting for the asylum interview 5 years. There's a law that gives me another status because the time I've been waiting. Marcy, no, there is none. Is that Elio? I'm sorry, did I jump? Elio. Oh, I'm sorry.
Elio asked that question while we're waiting for Marcy to type.
Elio, you don't get an automatic status just because you're waiting for something for 5 years here. You're asylum pending. That's your legal status right now.
And Gil, that's an important note. I actually got that question yesterday, so there has to be something going around. But no, your wait time doesn't entitle you to some sort of benefit, and that goes across the board, really.
Yeah.
Let's see. Any news from Juarez? Nirvalma, Juarez, the U.S. Embassy in Juarez is moving. Yeah. It's open. They are doing appointments, and we're good. You can go ahead and apply there. Natalia asked Gil, how long is the E2 taking, and can I also apply for it with as a domestic?
Can I take my domestic? Yes, you can. The E2 is eligible for that. Marcy, I'll get to you right now. And E2 depends on the consulate. Get ready to wait 5-6 months for a consular interview. Things are moving slowly. Get the E2 in as quickly as possible so you are in chronological order. And that's how I've been in touch with 3 separate consulates this week, Stephanie. Everybody basically telling me the party line, which is, where we understand that there is a long wait right now and that you've been waiting. Unfortunately, we cannot give a time estimate as to when you will have an interview. I have requested for emergency interviews because there's U.S. businesses that need the owners here in the United States. And the reality is that they don't really care. And so I say, get the cases in as quickly as possible. Get ready to wait. That's it. Let's go to last one.
Marcy's question. We were waiting for it.
Oh, their question is, someone's visa expired and stayed in the USA. Then he wants to go for investment visa. Can he get a green card like that? So, Marcy, the issue is this. What was the overstay like? Did you overstay 1 day? Did you overstay a year? Okay, the reality is you're not going to get a work visa, an investment visa. You may be eligible for a green card, but very likely if you're in the United States, the only eligibility for the green card you have may be marriage to a United States citizen. That's the truth, okay? Have an appointment with us. We'll see what we can do.
Danny has a question. His uncle had a social security number 5 years ago. If he enters the U.S. again, can he work? Danny, he can only work if he has an employment visa or if he has permanent residency. Okay,
or work authorization.
Work authorization. Yeah. If he just because he has a social, that does not authorize him to work. He has to have some sort of secondary document that authorizes him to work authorization, a work visa, green card, something else has to authorize him to work.
Call us, Rocruz. Just be in touch with us. If we could waive, many times we waive the consultation fee for people and obviously people in need and stuff like that. So feel free. Thank you so much. Feel free to contact us, and if it's something that we could waive, we'll waive it for you. Last question. KV. Buen día, ¿cómo está de Honduras? ¿Sabe si están enviando casos ya a las embajadas? They are sending cases to the consulates. They just are not actually. So the NVC is quite active, and the NVC is getting everything together, and they are and they're sending off files to the consulates. They're just not necessarily scheduling interviews yet. That's going to be the issue. Okay. All right, guys. Thank you so much. It's been a pleasure. Stephanie, thank you so much. And hopefully everybody has a great weekend. Take care.
Thank you.